From the National Association of Consumer Bankruptcy Attorneys, this is NACBA Now, with your hosts Gene Melchionne and Jim Haller, discussing bankruptcy law for the busy consumer bankruptcy attorney.
Hello, Gene. How are you today?
I'm fine. Just fine.
Excellent.
And not recovering from any kind of shots.
Yeah, unfortunately, I am. It's one of those rules seemed like a good idea at the time, and mistakes. I really need to get one of these shirts I saw on Amazon that says, it's not my fault I was left unsupervised. And anyway, so we have some interesting stuff from the Caselaw update from October 12th. A few interesting cases. The first one is out of the First Circuit, In Re Shove. And interesting case where the debtor owned a business and for years and years kept his business records until 2015, when the business records were involved in a house fire and they burned all up. And after that, the debtor did not keep business records. And also during this period of time, unfortunately, he had an employee that was injured, and to the tune of about $1 million judgment prior to filing. And when the debtor filed his Chapter 7 bankruptcy, trustee asked for a bunch of records. Debtor didn't have them, and there was an objection to discharge under 727A3, which basically states that a debtor has a duty to maintain books and records memorializing their business affairs, or have a pretty good reason why you weren't able to do that. Thoughts?
This was one of those no-brainer kind of cases. Either the debtor was hiding the records, or if he didn't keep them, that's even worse. And because when you read the case, they talk about rent receipts being the major part of it, and it being received in cash, you can't even produce bank records that might help back up some of the business records or recreate them. So this, to me, was a no-brainer kind of case. It was, of course, that's going to result in the denial of discharge.
So there's an interesting defense. It's called a justification defense, which is basically my record keeping was reasonable under the circumstances, because a lot of records with regard to, having a few rental units is not unreasonable, and that his family was going through some difficult issues. And the court said, well, that defense is objectively reasonable. Unfortunately for this fellow, he had a long history of a business and rental property owner, and he had been keeping records up to the 2015 fire and not so much afterwards. And so that failure to keep records was unjustified. So if your client's been keeping records and all of a sudden stopped, that's a knock against him.
I think he's got a bigger worry too, because if the IRS reads this case, I think that would result in a huge audit and maybe a examination of his taxes.
Yeah, absolutely.
That's a problem.
The next case I understand, but I don't agree with it, but I understand it. It's Solis versus Curtis out of the Fifth Circuit. And in this situation, a tractor trailer owned by the debtor's company got into a vehicle accident where two people were killed. And the insurance company started representing the debtor, and there was $1 million cap. And the insurance company settled with the attorney for one of the family members, because both of these accident victims died, with one family for the amount of coverage, and then the debtor filed bankruptcy and listed, the other family, and the trustee said, "Oh, that was done pretty soon, right before the bankruptcy was filed. I'm going to try to claw that money back." Thoughts?
I I think I fall into the same category as you. The code where I attached to this was wow, because it would seem not to be property of the estate. But the whole argument over whether the debtor could control the insurance policy or not seemed to be pretty clear to me that that wasn't the case. But the court found otherwise.
Yeah, and the court
Little
found,
confusing.
yeah, that the pre-petition payment of insurance proceeds, made even in accordance with the state insurance law, still constituted a transfer of interest. And this is one of those situations where, I mean, it really kind of comes down to, if you have kids in preschool and you have one sandwich and two kids who are hungry, you usually would cut it in half. And in this situation, one party got all the money and the other party got no money. And so that issue, particularly when we're dealing with the death of the essentially the creditor's family member, I'm not surprised at the result. I feel terrible for the families, because this is doubly upsetting for them, thinking it was settled and then it's not settled, and then having to go through bankruptcy to get paid. So that's a tough beat.
Yeah, ultimately, when I started thinking about the case, that's really what it came down to. You got this one chunk asset, and you've got two claimants, and of course, you're going to have to split the baby. So,
Yeah,
yeah, it made sense to me in the end. It's just that it was a tough one to follow.
yeah. Next one is bankruptcy court out of the Eastern District of Pennsylvania. Case is In re McKee. And the unfortunate situation of a former attorney, having filed for Chapter 7 bankruptcy. Evidently, prior to her filing bankruptcy, she had been involved in some disciplinary matters with the Disciplinary Council of the Pennsylvania Supreme Court. There was a consent judgment with regard to her misconduct. When she, the issue is some of this had to do with money going to clients, and in Pennsylvania, there's also an entity called the Pennsylvania Lawyers Fund for Client Security, which is also an entity of the Supreme Court. When the debtor filed bankruptcy and listed her creditors, she unfortunately did not list this Pennsylvania Lawyers Fund. And but she listed the disciplinary commission and all of these entities basically share a building where they work in. I think they're even on the same floor, but they have a different address. And so in this situation, the client fund came in and said that this debt should not be dischargeable. Initial thoughts on this?
This was an interesting case because of the long discussion about collateral estoppel effect of the consent judgment, or whatever you want to call it, for the disciplinary proceedings, and then the determination of what the penalty was, and in characterization as to whether or not it was supposed to be payable to the clients or not. And the great thing here in this case that I found interesting was they cited the Robinson case from Connecticut, which went to the Supreme Court about dischargeability of criminal restitution, which is a case that I actually was involved in personally, representing a credit union at the time. So I read this case. It's a long case. There's a lot to it. But then there was that personal interest part where they cited something that I have familiarity with.
Yeah. And in this case, they found that the debt was non-dischargeable under 523A2A. What I found it was interesting is that because this creditor wasn't notified, the court allowed this fund to come in and reopen the bankruptcy and file a 523A2 complaint, despite the fact that it wasn't filed within the 60 days of the 341 meeting under Section 523C. Generally, that's a bar, but in this situation, the bankruptcy court let it go forward. I didn't see it as an issue on appeal. Usually in this situation, I usually see an adversary under 523A3 basically saying we weren't, we were never noticed, and so we just want to have a comfort order that the debt is non-dischargeable. But the court did a very good job going through the different parts of Section 523A2A, and then the court also talked about whether or not the debt was dischargeable under 523A7, which makes non-dischargeable certain amounts payable to a governmental governmental unit, and is not compensation for actual pecuniary loss. And the debtor in this case argued, well, the money that they're seeking to get back is the money that they sent to my clients.
Right.
And
yeah, this was a long and detailed discussion. I found the collateral estoppel arguments also interesting.
Yeah, I mean, in this situation, the court said, well, this is really more of a penalty than it is compensation. But let's talk about collateral estoppel. Interesting. There's issues here on if there's a stipulation or a consent in a prior case. Does that collaterally stop you from litigating those issues? In a subsequent situation. Thoughts on that? What do you think of the court's opinion on this issue?
Whenever you start talking about the collateral estoppel issues, I have to go around and start from scratch and thinking about those things. I agreed with it. It made sense to me, but and it was good that the judge went into a deep discussion about the effect of that process.
And it has a couple of good principles of law, which is that general stipulations are not entitled to preclusive effect. However, in this situation, it was because the court didn't just rely on the stipulation from the state court. So, very interesting decision. Again, another decision that you could kind of see coming. But based on the facts, the next argument, the next case I found very creative, but I'd never heard of this working. It's In re Lambert, the Bankruptcy Court of Northern District of Georgia, and in this situation, the debtor filed a Chapter 13 after filing. The creditor submitted a Form 1099-C. Showing cancellation of debt with the Internal Revenue Service. And the debtor got wind of that 1099-C and filed an objection to the claim saying that, well, they've charged it off, so there's no debt. And so the issue is, does the issuance of a 1099-C form mean that you no longer owe the debt? And the answer to that question, Gene?
Never. You still owe the debt. This is an issue that comes across my desk all the time. Oh, well, they charged it off. Well, no, that still means you owe the debt. It's just a question that, and in fact, the relationship with the tax, if the debtor actually ends up making those payments under Chapter 13 for that discharged for that 1099-C debt, that becomes income to the creditor, not a recovery of any sort. So there's interesting tax aspects of this stuff, but the fact of the matter is, just because it says it's discharged, just because you got a 1099, you still owe it. It's still a debt.
Yep.
And
So,
it was perfect sense to me. When I read it, I went, I know where this is going.
yeah. And creative argument. I like it.
Yeah.
But no. They said it was a required form that they had to file, and it doesn't operate to establish that the debt is no longer owed. The last case that we have is Henry Williams, Bankruptcy Court, Eastern District of Virginia, and this was kind of a situation that I think a lot of bankruptcy attorneys fall into. After the Chapter 13 bankruptcy was filed, the mortgage company continued to send mortgage statements to the Chapter 13 debtor's attorney, despite multiple requests to just send them directly to the debtor. And so the debtor's attorney in the bankruptcy court filed an adversary against that mortgage company, and one of the counts was under the Truth in Lending Act, and the court basically said, well, what's your injury? It went to your attorney, and so how are you really harmed? Thoughts on this?
This is maddening for me when I constantly get statements that are meant for my client. I tell the lender, go send the statements to my client directly, and they don't do it. Or even worse, they just don't send statements at all. So I can understand where it all comes from. And I'm not sure I agree 100% with the decision, because the fact is that there is a problem here. But I get the fact that there wasn't any real damage. There really isn't. She didn't miss any payments as a result of this. There wasn't any emotional distress or other collateral kinds of issues in terms of damage. So the end result made sense, but it's so frustrating as a debtor's attorney when you get this mail and you keep having to send it to your client saying, look, make your mortgage payment.
Yeah, I was kind of hoping as I started reading that opinion that maybe there'd be a different result, something that we could use to prevent that from continuing to happen, but unfortunately not. Anyway, that's all we have for this week. Any final comments on these this week's cases, Gene?
Isn't it enough? These cases were killers.
All right. Well, we'll be back soon with another case law update. Thanks, Gene. Take care.
Thank you. We'll see you guys around.
Thank you for listening to NACBA Now and your continued support of NACBA. You can find additional materials to assist you on the member dashboard page at NACBA.org. Educate, advocate, litigate. NACBA.